So, we're not live yet now. Please tell me before we go live.
Sure. When everyone's ready, we'll go live then. Is the voice and audio clear?
Yeah, yes. Now it is.
Good.
Ma'am, then there is one question regarding an incident in Bihar where the magistrate put the rape victim and her caregivers in judicial custody under contempt because she was disillusioned. So I will ask you regarding that. Like, that will be one of the questions.
And we're just ready to go live now. If, that's okay.
Just let me tell them 2-3 more questions.
Yes.
Then, ma'am,
Hello and welcome. Good evening, everyone who's joined in from our YouTube channel. Thank you very much for joining in. We at Lex Macula are extremely privileged and grateful to host Ms. Pinky Anand and Ms. Geeta Luthra, senior advocates, to join us for this session on how India reacts today, sensitizing the legal system. The moderator for this session is Ms. Janvi Sharma, who is an advocate practicing in the Delhi High Court and the Supreme Court of India. She specializes in intellectual property rights, constitutional law, international relations and diplomacy, and family law. Ma'am is a mediator. She is skilled in drafting, arguing, and legal research. She does a fair share of legal advisory and consultancy work for a number of individuals, companies, educational institutions, and organizations. Ma'am has a background in political science honors from Hindu College, Delhi University. She is also an avid reader who writes poetry occasionally. She is closely attached to the Virtual Lawyer, the Instagram handle, which is an initiative to enhance virtual legal education through live sessions. The Virtual Lawyer has conducted over 65 webinars and live sessions. So we are extremely grateful that ma'am will be moderating this session on our behalf. Ma'am, on to you for introducing the panelists and carrying the session forward.
Thank you so much. And I would like to formally welcome everyone who has joined in today. We understand that it's a Sunday and you're taking out time to hear a discussion on a very important topic and something that is very close to my heart as well. We have very extremely, I'm very starstruck today with our panelists. So I will start my introduction with Dr. Pinky Anand. Dr. Anand is a designated senior advocate practicing in the Supreme Court of India. She is a former additional Solicitor General for the Union of India. She has a doctorate in law. She is a graduate of Harvard Law School. And on top of that, she's an INLAC scholar and the second woman to be awarded this particular designation. Ma'am has been the Vice President of the Bar Association of India. She has received several awards of excellence in law by Bharat Nirman, PhD Chamber of Progress, Harmony and Development, as well as from FICCI. Ma'am headed the All India team for Bharatiya Janata Party and for several years and has been their spokesperson. She has worked tirelessly for the rule of law and for social development and achieved numerous milestones in her various endeavors. Ma'am is currently representing India in the formation of the BRICS Legal Forum and is also serves as a member of the Indian delegation to Brazil. Ma'am, we welcome you here. We are very honored and humbled that you came and you took out time from your busy schedule to discuss such an important topic. Ma'am, over to you now.
Thank you, Janvi. I'm really grateful to Lex Macula for having us on this webinar. And indeed, this is not the first of our experiences with some of you, and Janvi particularly with the virtual lawyers. We've had a pleasurable occasion to go for a webinar in that also. I welcome all the students, and I must say that considering that the subject itself is so dismal and so bleak, your smiling expression definitely leads the way forward. So I think we look always forward to a positive outcome of some situations. And I think the intention of discussing any subject of this kind of bleak nature is indeed to give it strength, to give the subject strength, and to ensure that we can put an end to these kind of miseries. I must say, crime never comes to a finality. You can't ever say that crime will go away. But whatever we can do to reduce this incidence, and I think for that, what you need to do always is constantly, particularly in issues of sexual violence, is to ensure that we go behind the social fabric to see where the shoe pinches and to try to address that. Now, with this in hand, I would say that we have indeed a very positive outcome overall. And I think if we look through, and I will go through very briefly of the amendments and the various manners in which India has made substantial progress in dealing with this malaise, if I may call it. But nonetheless, I think what we have come to is a stage where we have recognized the issue of gender equality as a mainstream subject. And I think that is of extreme importance. And I'm not saying this only about the subject of rape, but I say this across the board. Because I think for the first time, possibly in at least centuries, if you take it in that kind of time frame, we find that it has become a subject of issue, empowerment, basically ensuring against physical violence, mental violence, sustenance, even matrimonial laws. The whole concept has become, so we've had across board all these issues which are coming up, whether you take triple talaq as a practice which is antithetical to human dignity. So I think the whole subject is that of human dignity, and I would like to identify the subject as one coming under the umbrella of that broader theme, and not only gender equality as much, but of human dignity. And I think that is where rape seems to strike at the root of society, because rape has been, and we have held it not only by way of thought, but by way of expression in various judgments, in various discourses, that rape actually is a fundamental violation of human dignity and a violation of Article 21, and basically robs a woman not only of physical issues, but also of mental, and leaves the victim completely prone to complete instability as far as life is concerned. And therefore, there is nothing possibly worse than rape to deal with crimes. Possibly this is the worst at the bottom of the barrel. So with that, I think let's come to where we are at present. And we do find, I've somehow lost the main frame, but I hope I'm being heard. So we do find at this point of time that the figures again indicate a very bleak situation as far as rape is concerned. I'm sure some of you could have seen and would have noticed the NCRB, the National Crime Bureau, figures in 2018. But there are some couple of interesting features that I wanted to just put out across. And the reason why we are coming to the subject today, also in times where questions are being asked relating to some judgments and how they seem to find the concept of a perfect victim. Now, it might be good as a title elsewhere, but definitely there's nothing called a perfect victim, and there's nothing called a good or bad victim, and there's nothing called a good or bad survivor, whichever category we bring in, because it is very important to understand the notions that run along with the question of rape. NCRB data indicates that there are about 30 of rape, out of which 1/4 are against minors. Now, that again is a very, very important issue that we must outline. It seems, as demonstrated by reported, and we must take it that rape is not reported in entirety. Rape is reported ultimately more as a matter of, in a sense, exception. Figures are increasing, reportings are increasing, but traditionally and canonically across the world, you find that rapes are lesser reported than reported. But one fourth being minors is a very extreme indication, and we'll come to that in a little later. About 50% of the victims are between 18 to 30 years of age. Now, that indicates yet another feature. 50% being 18 to 30 means that you are talking about possibly a situation where victims are not being raped by outsiders as much, but by acquaintances, partners, online relationships, and whatever goes further from there as knowing somebody, so to say. 94%, in fact, NCRB also reports, of the offenders are known to the victims. Now, that is a feature of modern India, if you like. Of course, even earlier, you found that within families also, there was extreme perpetration of violence and of sexual assault. It was not unknown. But today, I think even that has gone a little beyond the direct family into other relationships. So you have about 94% offenders who are known. You have 1,56,327 cases on trial at present, approximately, which are there, out of which only 17,313 are decided. Of course, we must also take into account that rape cases, as much as any other criminal cases, do take a considerable time to complete. There are some exceptions, as some of you must have noticed. There was a case in Jodhpur, for example, which got decided in 3 months. There was a case I still remember which was decided in 22 days. But those are again the exceptions, and by and large, criminal trials do seem to take a considerable length of time and progress right up to the Supreme Court on most occasions, as most criminal trials of the country do. You've had conviction out of this 1,56,327 cases of about 27% conviction, which is about 4,708. The rest are acquittals or discharge. The figures, I must say, are not still too bad in the current context. We need to, of course, improve them. But the question is that we do have a rising rate of conviction. And sometimes when we talk about dismal areas, I do think we go across to find that a number of criminal cases today in respect of rape do land up in conviction. And that is a very good feature, because ultimately you need justice for all. And that is what does propel you onto justice. Coming back to the question of how this all began, I think we don't need to really trace this too much, but basically it seems to be coming from a Latin word called rapier. Rape comes from there. And it basically means to steal or seize. And this entire concept of stealing or seizing was of a person's property. Now, the traditional concept of a woman has been property or chattel. And that has run across criminal jurisprudence as much as other jurisprudence, but more particularly in criminal jurisprudence. So therefore, there was considered no crime, except if you raped somebody else's wife, in which case the offense was against the other man rather than in respect to the wife. And that is something, I think, which we've had to deal with for a long time. And therefore, empowerment, as I say, is always connected with that concept, because you do need to have empowerment to displace this traditional antiquated notion of property, woman being property, and therefore subject to being violated. I was mentioning to you that we have had considerable address on the criminal side and the legal side as far as rape is concerned. And I think it has been an amazing progress. If you see 1860 Act, Indian Penal Code is of 1860, and we took it from the English Times. At that time, the punishment for rape was 2 years, which was the same as perjury, and highly questionable, of course. In due course of time, today we have finally, even in cases of minors, we even have death as a sentence. And I think that is one of the radical transformations that has gone across. Of course, it is in a limited context, but otherwise the punishment has gone up to about 10 years. But let me just trace to you some of the sequences that have happened, which I think are critical to evaluation of the law on the subject. I think it all began, in a sense, this entire controversy about how to deal with rape and how to improve the legal systems. The first case was possibly the Mathura case, which was finally reported as Tukaram, where the woman was raped and was considered to be of easy virtue. and the policemen who raped her were acquitted. And that led to a furor. That finally led on to the introduction of Section 114A of the Evidence Act, which did away with the presumption of, or rather, brought in the presumption of consent and of custodial rape. I think custodial rape itself is an extremely important feature because it is very much known to exist in Indian society and seems to be pervasive across board, whether it's institutions, whether it is authorities, whether it is in places of, let us say, institutional, even educational institutions. So you do have a number of instances where custodial rape itself, because a victim is compromised, is available there in a situation where she's under, in any case, fear of the accused, so to say, or the offender, so to say. So this 1973 led on to this. Then we had Bhavari Devi. Now, Bhavari Devi itself was a major event in the landmark of rape issues and of the rape context in this country. Bhavari Devi was a woman social worker who was working in Rajasthan, and she was gang raped. And that, I think, again, transformed some of the surfaces of Indian legislative history. And with that came some of the changes, but in particular, I could mention one of them and some followed later. One was the deletion of 155 subsection 4 of the Indian Evidence Act. Let me not name the sections. As lawyers, we all have access to the books as and when required. We can refer to them even in an open book examination, by the way. But the basic issue was that you could not cross-examine a victim in a rape case on her morality or character. So that was really the essence of 155 subsection 4. And while we talk today about some of the controversial judgments, which we will be talking about, you must remember that at an era when these provisions did not exist, the typical kind of issue that would come up is the accused lawyer would always discredit or try to discredit the victim based upon her character or her virtue or her morality and each of these features. And in fact, these came into limelight considerably in a number of cases in India at that time. And that is the reason why these provisions had to be dealt with in this manner by deletion of Indian Evidence Act, Section 155 subclause 4, and addition of Section 146 also, which similarly dealt with the same question that you cannot discredit a victim based upon her character or her morality, so to say. Following this, 2012 witnessed, before 2012, 2005 actually, witnessed 164 ACRPs. This was relating to medical examination. This became an imperative. We had a history of something called the two-finger test, which arose from chastity and virginity, and these absolutely patriarchal and archetypal notions. This was done away by a judgment as much as by the law, because once the law came into being, you had the provisions which provided how you would have medical testimony being conducted, in what circumstances, and it should be conducted within 24 hours is the basic essence which we are talking about, as much as the fact that the Supreme Court laid down that the two-finger test was something which was not acceptable and therefore should not be conducted in any manner. Followed this, the POSCO Act, which ultimately brought in a different category for children. I say this because by and large, women and children are the victims of such kind of offenses. Then, of course, if we can, I would like to jump across a bit to Nirbhaya. Now, Nirbhaya is a case which has been in stark light as far as the Indian society is concerned and civil society is concerned. And I think it brought to the forefront a complete episode of how there could be traumatization, victimization, attack, assault, and complete abdication of any kind of responsibility. And in fact, on the contrary, finding that there was absolutely draconian actions on the part of the accused, and brutality, which led to, of course, a death sentence, and it has culminated in that. But what was interesting was, and this is why I bring in the civil society at a lot of times, 2012 incident brought to the forefront civil society, such as yourselves, Janvi, and a number of other youngsters. And I think that paved the way for major legislative changes and a change of perception. And of course, I think when civil society steps in, you do find that justice seems to veer in absolutely the right direction. It was a helpful situation. We did find the conviction happening, and we found, if you look at the judgment, you would be aghast at the kind of brutality perpetrated by the accused and the kind of visions that the court did see and point out as far as rape is concerned. But Nirbhaya followed a spate of amendments. Justice J.S. Verma committee, is unfortunately not with us anymore, brought to the fore not only broadening of sexual assault, because rape became literally defined within sexual assault and a broadening of that, but acid attacks. Now, rape also, by the way, it's a well-known feature that by and large, rape is actually the culmination of a series of activities, and rape is right at the bottom of the barrel or at the top of the offenses, whichever way you look at it. In a sense, it actually graduates sometimes. There is this graduation concept that is there. So you start with the lesser, literally as sexual assault in the first instance, where you might have not a direct rape, but it actually lends itself on to going further and reaching rape as the final part of the issue. So you had 2013 amendments, as I said, which dealt with stalking, because what are the precursors to rape and what are the precursors to the situation of these offenses? Stalking, voyeurism, it leads and lends itself on to the higher crime, which is rape. Acid attacks, of course, as I mentioned. And it also increased the punishment from 7 to 10 years. It increased the punishment where you left the victim in a vegetative state to 20 years. Um, I will just now mention, as I said, in this series of slew of legislative amendments, the proposition of 2013, which ultimately dealt with rape for children under 16 years of age, which became 20 years, death sentence, as I mentioned, Janvi, earlier, to 12 years, and of course, this increase of 7 to 10 years that we have dealt with earlier. Now, this actually brings to fore that law itself seems to have taken into account each of the features that could result in positive conviction and in ensuring that justice is available to the victims. In fact, this is another philosophy that is constantly said. It should be the victim and the survivor. These kind of languages also are there. Now, I want to come to one other aspect, and I think I'll share something with you which is outside the complete legal text, so to say. However, it is of some interest to me because it's something with which I grew up. I saw a movie a long time back. I don't want to mention the years, but yeah, 80s in any case. This movie was called The Accused. Now, this was dealing with gang rape and in fact the issue of consent and no consent, and I think that is one of the critical issues that really features in most cases of rape, because by and large a very typical defense given is consent was there, either visible or invisible or actual. And of course we have Muhammad Faruqi's judgment, which dealt with a feeble no means a yes, and a yes doesn't always mean a yes, and a no doesn't always mean a no. Unfortunately, these are the kind of notions that we are grappling with, and we do have to continue to grapple with. So, coming back, in fact, I thought The Accused was a real story, but I did try to trace that, and I couldn't find a trace of that. However, fictional it might have been, but even so, this young girl, to bring alive the entire controversies, this young girl goes into a bar called the Mill after an episode and a fight with her boyfriend. And there she's very distressed, and in any case, she's trying to, enliven herself and make herself get herself out of this distress feature. And somebody puts on the music. This is a bar, as I said, and that's a jukebox, as it's called. Anyway, she starts dancing, and then people are watching her dance, and generally people are, continuing in that kind of happy mood overall. But then it starts changing. The situation starts changing, and she has had a couple of drinks. And I say this because you'll find something from similar from Indian texts also, which demonstrate the fact that these are some of the issues. How can a woman have a drink, and if she has alcohol, is she a perfect victim? And that whole philosophy of perfect and imperfect victim. So she is gang raped. The men who do the gang rape are let off on a plea bargain. Then this woman goes into her prosecutor. Catherine is her name, I believe. That's a fictional name, by the way, so it doesn't matter. Otherwise, names today you cannot really, though you can talk about the prosecutor, but not the victim. So she went across to her prosecutor, and she was very upset, and she started ranting at her. the prosecutor does realize she's a woman also, and she realizes that this woman has actually been exposed to this extreme brutality, and yes, there has been injustice. So she finally goes and pursues a trial against all the people who were cheering on the gang rape. Finally, she gets a conviction, and there is also some revisiting of the sentence of the gang rapers, so to say. And the entire issue was, do you consider or should you consider the question of perfection or imperfection of a victim? Can you consider whether the woman has been in a compromised position? Can you consider whether the woman's dress is an issue which should be discussed? Can you enter into the domain of whether she had alcohol? And I think that is where the current context would become extremely important, because, as I mentioned to you, and I link it back to that 94% of people are known. So the question of a number of cases that have come up, and we'll see this across various jurisdictions. And I'll just point out to you some of the Indian texts that have dwelt on this kind of aspect. But you would find these very typical kind of comments which are coming across, that a woman was not, she should be inconsolable, she should be distressed. If she went to sleep, she can't say she went to sleep and therefore she was raped earlier. So we can't really deal with that. But before I come to that, I must come to another case which is extremely interesting, which is a very current case by Justice Reddy and Justice Lalit, which in fact dealt with, of course, today's names are not there, so we are Miss XYZ versus the state of Gujarat. And in that case, this lady was working in an institution and she was blackmailed. And finally, there was rape committed by the employer, so to say, or her supervisor. That led on the case to a settlement, and that settlement was something which the High Court accepted. When the matter came up to the Supreme Court, in fact, went into this entire issue of consent. And they said, firstly, of course, the settlement itself has to be looked into and the investigation should go on. So the settlement portion, or rather based on the settlement, was set aside. The matter was sent back to further thought and consideration. But aside from that, the court said and dealt with Section 114A. I dealt with that earlier, which deals with the presumption of no consent. And in that context, the court said, when it is held that a woman says she did not consent, the presumption of consent stands in her favor. And that is what must prevail. Of course, even the settlement was said to be under coercion. So that was another aspect which came into this entire background. So very heartening to see that, in fact, there has been a complete consideration of this, considering that there are some, either one can call them exceptional cases where these issues have been noticed. Now, this is where we really need to see. We need to send the record straight. We need to determine and put for the record what needs to be considered when a rape trial is on way. Can you go into these archetypical notions of what an ideal victim is? And I believe Nils Christie is somebody who expounded this ideal victim theory a long time back, possibly in a yesterday's or yesteryear's concept. But in today's time, it is most misplaced. You do have women who are engaging in professions. You do have women who are engaging in academics. You do have women who are empowered. You do have women who are out rubbing shoulders, if you like, along with their colleagues. You do have people who are engaging in entertainment. You are having people engaging in social exercises. So if you actually put at naught any kind of offense on the ground that there is a question of either chastity or morality or short skirts or alcohol or fatigue or any of these typical notions of so-called Indian women, I think it would be extremely misplaced in society. With this, I would like to just dwell for a moment into some of the concepts that had come around very briefly, because they are of extreme interest, and we must point out these aberrations always so that we can correct the same in whichever fashion that we can. Now, in one of the Karnataka High Court judgments, of course, that issue was expunged subsequently, but there was a lot of furor. Now, coming to the Karnataka issue, which was noticed, what was stated by the court itself, the order in so and so, I don't wish to name the case, noted that the statement of the complainant that after the perpetration of the act she was tired and fell asleep was unbelievable, because this is now how an Indian woman would react to being raped. Unbecoming of an Indian woman to sleep after being ravished, not how our women react. The Karnataka High Court Of course, this was while granting bail to the rape accused, and that also incidentally is of significance because the question of bail is extremely critical to this entire position of trial, and particularly in a situation of controls that a lot of accused have. In another case, the Supreme Court opined and held that the victim was not hurrying back home in a distressed, humiliated, and a devastated state. It was unusual, and the veracity of her testimony was suspect. Uh, Again, an extremely question mark area, which I think deserves some decent thought. Um, then another version of High Court. It is a prime responsibility of the woman in the relationship to protect her honor, dignity, and modesty. A woman should not throw herself to a man and indulge in promiscuity, becoming source of hilarity. It is for her to maintain her purity, chastity, and virtues. I'm sorry, but this sounds extremely unbecoming in any context. And that's why I mentioned the accused to you, because I thought that really brought to the forefront simply because a woman was in a bar, simply because she was dancing, simply because she was a subject matter of some attention, cannot ever give any man a right to rape her. Leave aside a situation which arose possibly in one of the cases that I mentioned, and everybody is well aware of, which stands out in respect of a feeble no. You have some others which have come out as far as a dissolute lady is concerned, a woman of easy virtues. This again are some of the question mark areas that has come around. She used to do all dirty things, has been said in one of the high courts. She aggressively resists rape and does not submit to it, a notion that is required. Now, again, in the context of how and when a rape does happen, the question of resistance seems to be good enough. Question of no consent itself, as I said, seems good enough, and that is about all that is required under Section 375 of the IPC. Whatever may have preceded or come subsequently is not of a very material issue there. Just to give you one of the overturning of a conviction in one case, her conduct during the alleged ordeal is also unlike a victim of forcible rape and betrays somewhat submissive and consensual disposition. From the nature of the exchanges between her and the accused persons, as narrated by her, the same are not at all consistent with those of an unwilling, terrified, and anguished victim of forcible intercourse. Um, then, once again, the prosecutrix was supposed to attack another case. The prosecutrix was supposed to attack the appellant like a wild animal, but she did not even resist. Thus, her conduct suggested only and only her consent and will. On the same context of resistance, there are several others. Let me go to another subject here. She is not an educated or modern woman. That is the expectation of, again, a victim of rape. And what was said in one of the cases, here is a complainant who appears to be quite an ultra modern lady with an open outlook towards life, enjoying alcohol in the company of men. She does not appear to be such a vulnerable lady that she would not raise her voice on being immensely exploited over such a long period of time. So you have these typical gender roles which are found in some of the judgments, and I think these definitely require a relook and a revisit. And to some extent, we need to lay down the law very stringently insofar as construction of consent is concerned. A 375 IPC, despite being an 1860 Act provision, does seem to encompass most of what was required, and whatever was missing was ultimately amended later on after Nirbhaya's case, and the sexual assault definition expanded to include all possible instances of a rape. I think it does lead to a complete humiliation and violation of the dignity of a woman. We do need to consider each of these aspects, and what ultimately we need to do in these cases is to ensure that each and every part of social values that goes along to make such offenses continue or permit such offenses to continue is demolished at the first instance. I would like to bring up one other subject at this point of time. I have been a part of a campaign which is dealing with saving the DNA. And I think these kind of scientific evidences is something that needs to come to the forefront. For example, for the time being, what I understand is there are only about 20,000 DNA tests which have been done over a year, and I think this campaign merits a very big consideration on your forum as much as on the social forum and the legal forum. Scientific evidence which conclusively proves sexual assault is something that needs to be considered and done at all levels. And I think every effort is being made. There is a bill which is pending, which is also, I hope, soon in the coming. But in the meantime, we must make all the efforts we can to have as much scientific evidence as we can to ensure that rape victims get justice from the courts. And finally, I think what is most important in all these offenses, which include sexual offenses such as rape, is the fact that we must have justice delivery, because that ensures that you give succor to the victims and the strength to the victims to actually come to the forefront, failing which they would unfortunately be left on the sidelines, which is something that we do not want. I think we have done commendably well as a country, and I think we can progress even more in this direction, thanks to some of you youngsters and the civil society, which has been taking up this issue at the highest level. Thank you very much.
Thank you so much, ma'am. That was a truly enlightening session, especially the fact that we now know that, what is majorly lacking is scientific evidence. And not many people focus on the need to improve the collection of scientific evidence, the production, the admissibility, and the subsequent analysis of the evidence that must take place. And speaking of the movie that you said, I've also watched a number of shows, and I realized that this is one of the main differences between India and some foreign countries, that here in many cases it's the character which is assessed as a reference point to decide what is what actually happened, rather than analytical data, which should be the primary focus as per me. Thank you so much, ma'am. I will catch you back in some time for question and answers. We have plenty of questions that have come in. I would now like to introduce our second speaker for this evening, Geeta ma'am. Ma'am is a designated senior advocate practicing at the Supreme Court of India. She has a master's in law and an MPhil in international relations from the University of Cambridge, UK. She is the vice president of the Indian Council of Arbitration and FICCI. She has appeared as a counsel in a number of matters ranging from criminal law, constitutional law, arbitration law, and human rights law. Ma'am has been practicing since the 1980s, and she has fought dozens of cases relating to bails for women, bails against women, women's right to claim maintenance, as well as to claim properties which the husband, which devolved to the husband as from the ancestors. Now, she has been a speaker at various international forums and has spoken on various burning issues such as the criminal justice system, the recent amendments in Arbitration and Conciliation Act of 1996, the need for institutional arbitration, gender rights in employment, migration, change in rape laws, offenses against women, including sexual harassment, domestic violence, rape, dowry death, cruelty, and trafficking in women. Ma'am, I'm deeply humbled to welcome you here today, and we look forward to your address. Over to you, ma'am. Ma'am, you have to unmute.
Thank you. Since Pinky has given a detailed analysis or history of the law as it has evolved, I'll perhaps give a little more. I will touch on 2-3 judgments, but more than that, how do we sensitize people? How do we sensitize judges, and how do we sensitize lawyers and the public? Why is it that in a place like Thailand, you can go at 2 a.m. at night as a woman, wearing whatever you please, and nobody will look twice at you? You can perhaps do that in Bombay and nobody will look twice at you. You may do it in many other places and you won't be looked at. And you can do it in Delhi, and unfortunately, it's not going to be a happy situation if it's a place like Delhi or the NCR. So the first aspect is how, when we are talking about making the legal system more sensitive, yeah, my first thought is, how do we make first the public more sensitive? So after all, we are one country, and why is it that in different parts of the country it is more dangerous for a woman to go out, and in other parts it's completely safe? So there is something about our education at homes, because our education in schools is more likely to be similar in all parts. So the question is, our education at home, our outlook, our processes of thought. So the first thing is improve the environment in the house. The second thing aspect is there should be drilled into the minds of every person that there will be no tolerance to disrespect for women or sexual assault of women. So the first is, of course, educate your people. Second is the justice system begins with the police. If our policing is not more sensitive, we are actually achieving nothing. Because the reason that I can go out on the road, if the public or members of the public believe that they can take law into their own hands or they can disrespect a woman, the reason I can go out safely is that I should feel that I have a strong police that is omnipresent and that will come to my rescue. There should be, similarly, if you are talking about public servants, the conductor in a bus, the driver in a bus. The driver may be having his back, but he can see from his rear view mirror. The conductor in the bus has to have responsibility to ensure that there is no misconduct happening in his bus. Unless we realize that everyone's duty as a public servant is to maintain law and order and respect for women, you are not having people who will be sensitive to women. After the police, of course, the next is lawyers. How many lawyers would you see when a rape victim goes to them would behave with some modicum of not, they will have to query, they will have to ask questions, they will have to make sure their client would be ready for cross-examination, that their client is not contradicting herself. So they will have to question her. But the quality of the questioning should be legal and not beyond legal. Similarly, the courts. So one aspect is, of course, insofar as courts are concerned, the Judicial Academy. So we now have judicial academies, and as a standard in the judicial academies, and one goes to some to speak, the first foremost job is to sensitivize courts and judges I remember one of the first matters we had done was where a girl was purportedly troubled in a bus, and there was a boy from Meerut who would come to give evidence. And one of the questions the judge kept asking this person was, but why are you coming from Meerut just to give evidence in Delhi for this girl for the 20th time? So this person said, this is very strange. All I'm doing is coming to give evidence. I'm one of those, thankfully, one of those citizens who is conscious enough to want to give evidence when I have seen something. And the court was questioning him so much, and the girl so much, who is today a person, strong person in her own right, and she started like that. But she finally gave up the case. And that boy also, from somebody who was being absolutely strong about his testimony, somehow dwindled under the 120 adjournments when he had to come every day from Meerut, and also by being questioned by the court, but why are you giving evidence if all you are is a witness? Of course, he's a witness, so he wants to give evidence, and maybe he's a good smarten, so he wants to give a good, he wants to bring out the truth. So what happens is, though it's a very small example, but it shows that we need to have judges who are sensitive. So, as Ms. Anand said in the initial part, that case, I think it's 75 Bharbada Bhogan Bhai, and there were two other judgments which were precursors to that also, that can the testimony of a rape victim, would she be treated as an accomplice or not? And the court said no, as long as her testimony is not blemished, she does not need, she is a victim. She can't be treated like an accomplice. And that's how the law changed. Then in Supreme Court, there was another judgment um, which was also very relevant. There was an acquittal by the Sessions Court and then by the High Court in the rape case, because this woman, Banubai, was so called of easy virtue. And then she was raped, and the question that came up was, she's a person of easy virtue. And the court said, but that doesn't mean that her self has to be, that she can be violated just because she may be a prostitute in 10 other cases. Here, it was not with her consent. And that judgment of the Supreme Court, that what is the character of the woman, is something which won't be looked at. Now, how do you balance it? To my mind, even though the law has been changed and there have been amendments in the Evidence Act to this effect, that a rape victim's background or character would not be gone into, there may be cases where some aspect of it may perhaps become relevant in if the other person is alleging that it was consensual sex. And the truth is this. In fact, I think it was yesterday that a judgment came out that there was a girl who went on Tinder, and it was a dating thing, and the question was it rape or was it consensual? Now, there will be cases where a person has had a 20-year consensual or a 2-year consensual relationship. And then one fine day, the person alleges that this was not consensual and he raped me, then there's a matter of mine which is sub judice, but I'll just, and we don't know the answer. The answer will come from the court. But I'm representing the accused, and the court, one of the questions is that the girl says, for example, I don't remember the dates and I don't remember the name, it's sub judice. So the girl says on 20th January 1985, he took me home to meet his parents and had sex with me against my wishes. After that, for the next 2 years, it was consensual. But that first day was not consensual. So the court will have to determine that in those circumstances, would it be considered consensual if for 2 years you continue to have a relationship with the man, which then goes sour? Because, and some of these relationships over the period of time, we will say landlord-tenant cases which have been made into rape. Dispute over property made into rape, servant, and I can give you examples of all of them. Servant and employer relationship gone sour, made into rape or made into sodomy. So there will be cases of that nature. And then there will be cases of rape where the person may or may not know you, because the chance of rape with a person who has custodial authority over you, who knows you, cannot be weakened only because he knew you. Say a family friend or a relative, somebody who has access to a child, because everybody won't have access to a child. A neighbor may, a family friend may, an uncle may. So we can't just dismiss those. So the courts will then have to look with a very careful eye and be very sensitive as to, and I remember talking at the time of Nirbhay to some members of the team that were doing the investigation and who had been doing investigation in rape cases. And one of the things they said was that, look, ma'am, for justice, we should have consensual cases gone sour as a different bracket than those which are non-consensual, which are rape, which have to be punished with the strictest of punishment. So there will be two lines, and that's why Justice Gambhir, in his judgment, which some people don't like, and says that when you should be far, you were near, and now that you should be near, you are being far. Something to that effect. I don't remember the quote exactly, but it was one of those judgments. So there have been judgments and judgments. And you'll see that there are cases in which there is acquittal. Some of the judgments and the expression used in those judgments may be jarring to the present mind. But the question is, we have to see all the circumstances. There are judgments where Supreme Court in that prostitute case also said, but this is clear rape, even if she was a lady of easy virtue. So it is, on the other hand, Supreme Court in two judgments, one in which there was a delay of only 8 days, another in which there was a delay of only 11 days. I think one is called Raju, and I can't remember which state it is. And there are two of them where the court acquitted, even though there was 8 and 11 days delay, which sometimes And I've known cases where the Indian courts, and this is not in the West, have condoned 15, 20 years delay. But while we are being so sensitive, we have to realize that there are rights in an accused equally as there are rights in a victim. So coming back to what I was saying, and then I'll come to the rights of accused and victim, is this aspect where what I was trying to point out was that the Supreme Court and all the high courts, everyone has to be made sensitive to false cases and genuine cases and how to treat a victim. So in Sakshi, the Supreme Court says that there should be some kind of blind or cover or screen. But at the and then in another judgment, the Supreme Court has said that normally a POXO accused should never be called again because you don't want to traumatize a child again and again. But there can always be exceptions to the rule, because some of these POXO accused don't have recourse to lawyers. And you see some of them in one of the cases, pro bono matters, which I am aware of, that the man who was accused by an NGO was a person who was the uncle who's finally acquitted, but after having been in custody for 6 to 8 years. In the meantime, his own children have gone to an orphanage because there is no one to feed them. So we have to see the legal system in India has to be very cautious insofar as when a victim comes, and this is that judgment by Justice Lokur and Justice Deepak Gupta, that please be sensitive. When the victim comes, there are some of these judgments, one of them saying victim should have recourse to a lawyer before you interrogate her. Some judgments, this particular judgment says that be sensitive. If the person is a victim of rape, for her to come out of the closet and speak up, particularly if it is something happening within the family, is a Herculean task. And you have to give protection to such people. You have to ensure that such people don't go from the frying pan into the fire. Don't go from one vitiated atmosphere to another vitiated atmosphere, which may be a protection home, which is not so good. So how do we, firstly, I think maybe time has come for the age to be changed, for the minimum age to be changed. And this is something which I can't say. We have to look at scientific evidence, because if two young people elope, then question is, would you put the boy behind bars if both of them have decided to be with each other? And what should be that age threshold when it becomes statutory rape? So there has been a lot of debate in India as well as in the West, particularly in the West, because there is a concept or a thought that people are maturing earlier, that girls, boys studying in co-educational becoming friendly earlier. Now, the boy may be to blame, the girl may be to blame, but it cannot necessarily be that all cases are cases of statutory rape, even though both are at a younger age. So question is, should we reduce the age? So while we want to sensitize the judges, there is something known as continuing education. So to remain a judge, to remain a lawyer, you should be having to do courses, and particularly if you're practicing on this field, either in criminal law or in matrimonial, criminal, penal offenses, to be able to become more and more sensitive with the times. So there have been judgments, and there is section 228 which says name and identity not to be disclosed. But very frequently, you will see that the name and identity, even in national media, is disclosed, particularly in those offenses or those cases which are on social media and on printed media. So the court may not make it, but it comes out. And that is the first aspect, that the courts have to give that person some name, which is a pseudonym or which is a name, make-believe name given to the person, so that, and then you have to have classes. You have to have classes for lawyers, you have to have classes for judges, you have to have adult education, you have to have, most important, who do they face first? Not lawyers and judges. They face the police first. And the police, I'm sorry to say, is not sensitive. So now you may come to politicians, but politicians come from our people. And we've known a very prominent chief minister to say that women should not go out late in the evenings, who belong to the gender of women. So the question is, how and what can you do? So I remember once we were, as lawyers, the police was trying to make it more safe, Delhi more safe, and said, well, what would you do if you wanted to make Delhi more safe? So there were suggestions, including the suggestion that women shouldn't go out late in the evening or be working in jobs which involve night shifts. But the other suggestions were, have the place well lit. And there was a counter suggestion, I recall, women should go out in large numbers in the evening so that other women feel safe, and that there is no possibility of, instead of being scared and being in home, be out in larger numbers, have more lighting, have, so various suggestions. Fact is, the most important thing is education. And of course, one politician apparently said that have child marriages, then there won't be rapes. So we have all sorts of a huge spectrum. It's a spectrum which is interesting, but which obviously nobody will subscribe to. And I'm sure that there would be in today's days so much hue and cry that the person would then try and explain away or apologize for his moment of madness. But in any case, having said all that, how do you make sure that people are made more sensitive? And why is it that certain areas and certain jurisdictions are more unsafe? There has to be something wrong in us as a people. There has to be something wrong with our policing. So that's what we need to do. And when I say all this, I also do not subscribe to the argument that you should have all women's courts. I remember one matter which I did in the Supreme Court, where the gentleman was accused of a case of making films which were um, obscene. I think that would be the best way to describe it. And he said, I don't expect justice. There's a woman judge, there's a woman steno, there's a woman public prosecutor, there's a woman everything. So, of course, that argument was repelled and the court rejected it. But I'm saying that this can't be an argument either, because we can't say that all these centuries when we have gone for justice to the courts, we haven't got it because there are only male judges. So the whole system should be, whether male or female, the gender sensitivity should be such that whether male or female, there should, and I can see the time is 6:17 and you have to ask questions. So my last sentence on this is gender sensitivity should be such that justice is blind, whether it be man, woman, anyone. The fact is we should be trained to be sensitive to the issue before us and not be partisan, whether for women or against, while keeping in mind that women are an oppressed species or are not a gender equal species in today, even in today's state. And therefore, keep this, while we keep this, our eyes open to this, we have to be justice is blind. Thank you.
Thank you, ma'am, for giving us such a candid sort of a address of what today's situation is, and such relatable examples, which I think all women these days would be able to somewhere or the other associate with, especially the going at night in a group and the keeping a place well lit. I mean, those are some of the things you hear quite often, and even sometimes from your parents you hear that don't stay out late at night, and so these are definitely issues that we do need to deal with, and this reflects a certain kind of mindset which is changing over time, and it might take some more time, but I feel we're on the path. And if we keep working towards it, yes, it will reach a certain fruition at in the near future. So now I have a large number of questions, but I'm going to ask you only as much as you allow me to. And my first question is for Pinky ma'am. Ma'am, you spoke about the Mathura case, the judgment of the Supreme Court, and as you know, recently we've had this controversial order of the Karnataka High Court, where a certain paragraph was expunged later on, and it spoke about the character of the woman and the way her behavior post the heinous act, and sort of spoke about chastity and aspects like that. And I feel that there is an ideal rape victim image that has been created in society and somewhere in our legal system as well. So, ma'am, how do you feel the two judgments? I mean, here we have the Mathura case, and now we have this. So, how do you think? How far have we come, or is it still in the same line? I mean,
I'll be honest, Janvi. I did mention some of these, statements which came in the judgments or the findings, which dealt with some of these, if I may say, exceptional situations. I would say it's exceptional. I think days have changed, simply because there are either paragraphs or findings by courts which we, of course, have found erroneous, and as you said rightly, it's been expunged thanks to protests. These typical notions that prevail over time don't go away so quickly. So what you do find is, yes, there is a transformation overall, and it's a very positive transformation. It's a progressive transformation. Courts are taking into account basic requirements of criminal laws and of the sexual offences, and not really transcending into these areas and domains. But yes, each of the people, ultimately, whether it's justice delivery system, you are comprising from part of the society. If society continues to nurture to some extent, and as I said, the extent has gone down, but please believe me, and you will support what I say. So these are, let's say, pockets of thoughts amongst a large whole. So yes, there are pockets, and yes, we are all working to ensure that they are removed from the system to the extent that this cannot be. Firstly, ultimately, criminal laws are meant to really the state defines what laws are required in society. You do require laws, and you do have laws. There's no, this is not a discussable or debatable issue whether rape should be an offense or not. So once it is an offense, any kind of archetypical or stereotyped notions that we might have had, I think very quickly with these kind of find themselves vanishing. So that'll be a kind of vanishing statement down the line. As things do with change, it does take its own time. I don't, I mean, in that sense, say that it is something which cannot be considered. But at least, yes, it is not there very much prevalent in most. I mentioned to you the other recent judgment. That's why, as a contrast, to show it is not a continuous process of thought or judgments. So you do have judgments in every which way, and by and large, you are having judgments which seem to deal with the basic offense at hand rather than going into either character or behavior or any of this good and bad images or the ideal or the unideal victim. Victims are never ideal or unideal. That entire notion is antiquated. It's a misogynistic kind of statement. So I think we really have to get away from that.
Thank you, ma'am. Geeta ma'am, next question for you. You spoke about how we need to balance the accused sensitivity towards the accused as well as the rape victim, and not just one side of the coin. See both sides of the coin. So, ma'am, now this is a number of people have sent the same question, and we often get this question: what is the legal recourse in case there is a false rape complaint or it's a wrong case? So what is the legal recourse with the accused? And also, for example, in POCSO Act, if a young minor files a complaint and it turns out to be false, you can't take any action. So against the minor. So then what will be the legal recourse for an accused?
No, I think section 22 regarding POCSO answers it. That if the family is made a false case, then clearly there is recourse. I think it's 6 months punishment. I'm not very sure, but I think it's 6 months. So that's POCSO. As far as rape is concerned, the ordinary criminal law, where there is can be a malicious prosecution case. Question is, in India, we still have no recourse. For example, this man who was in for 6 years or 8 years and has now got acquitted, saying it was a false case made against him. I'm not getting into the background, and there'll be hundreds of such cases. There is no damages. There is no damages for false imprisonment. So the question is, and the courts are going to be saying we are already burdened with so many lakhs and crores of cases, we don't really want to bother about you. But there is, in rape cases, malicious prosecution. So you can file a case once the final judgment has come and there's no appeal or it's gone till Supreme Court. You can file for malicious prosecution. Most of the time, people are so tired of the legal system that they want to run as far away as possible instead of filing for malicious prosecution. And that's the truth. I get some people who in the initial stages are very upset at being falsely implicated. They're saying, ma'am, once we win the case, we want to, take this person to task. But by the time they win their matter and they are acquitted or discharged, they are so exhausted financially, economically, and emotionally with the law that they do not take recourse. But you have under POCSO 22 and under penal code, you have malicious prosecution. So there are remedies.
Thank you, ma'am. And I feel like this is one question that everyone asks, and there aren't enough answers in the law as of now. So, Pinky, ma'am, my next question to you. You spoke about the police. So we often find that the police sometimes does not register FIRs or is a little hesitant. And sometimes they might say that, there is a lot of political pressure, or there is the accused is from an affluent family, or the accused is a family member. So they say to the victim that, settle kar lo, ghar ka mamla hai, rehne do, those kind of things. So, ma'am, in this case, what is the legal recourse, or what are the small pointers that the accused can do at her end to ensure that something like this doesn't happen?
No, you're right. I mean, you find several cases where not only you're talking about settling, you even talking about proposals of marriage and saying you've been raped by somebody and you're having a child, marry the person concerned. So, I mean, these kind of issues keep coming up without doubt. But non-registration of an FIR is something which is actionable. You can appeal to the higher authorities. You can go to the magistrate under the Criminal Procedure Code and lodge a complaint under 156 and ask for the registration of the FIR. So there are provisions. But as you rightly said, the whole thing is of this position happening at the first instance. And to that extent, the laws have been made fairly more secure. You even have Lalita Kumari's judgment, which the Supreme Court laid down that in cognizable cases, you must have registration without any further recourse. And that is something which you can't be exempted with. So you are having the law made much more stringent, because conviction is something which comes after trial. The first stage which initiates the entire trial is the FIR. So if you don't have the FIR in place and you to run from pillar to post, that dissuades you. As it is, rape reporting is fairly low ebb, as we all know. And there's a second feature which you haven't mentioned, I will. The fact that rape often gets classified into other categories. So it will not come into the stricto sensu category of rape. I mean, this is a perpetual attempt to keep figures down, so therefore less reporting. So lack of reporting is on all these accounts. But the police asking for settlement is something that I guess only awareness and intervention of civil rights activists and others groups can ensure that you actually don't even consider that. But whether to prosecute or not to prosecute, I leave that as an open question for anybody, because that is another matter. Now, as I mentioned in the last case, which you were talking about, which ultimately the court found that the settlement was as a matter of coercion. Now, what if there is a settlement, a genuine settlement? So you have every factual scenario to be considered in its own aspect. But yes, the police cannot insist on any kind of settlement as a final step or a finale to an act of rape. It is something that is really up to the victim and survivor. In fact, that is another issue. Survivor or victim. Survivor is what is considered to be more appropriate.
Okay, thank you, ma'am. Geeta, ma'am, so you mentioned about how the rape victims, sometimes they don't have money to hire fancy lawyers. So basically, they will be going to legal aid workers or paralegals or volunteers. So, ma'am, do you think we need to have a system of sensitizing the legal aid community of our country, be it legal aid clinics or the legal aid society and the paralegals, and how to sensitize them to deal with such situations?
So the thing is, there are many people who do legal aid. Pinky and I have done a lot of legal aid work. So if you do legal aid with the wish to serve, according to me, you will be sensitive. And that's the only way and reason to do legal aid. And fortunately today, you have many young lawyers, even senior lawyers, who are wanting to do legal aid and help. The same way as I feel you need to make every lawyer sensitive, because you need to make them sensitive so that they can ask their questions in cross without being unfair, but do justice to their client. Similarly, the judge will has to disallow questions which are insensitive, but has to allow questions which will get to the truth of the matter, which may sometimes be hurtful by their nature. So there's a very fine balance which is required for lawyers, judges, and the entire justice system. Having said that, I'm sure why not legal aid lawyers should also be sensitized. They will be going to Tihar jail. looking at people who are accused. There will be lawyers who are amicus in matters. There would be lawyers who, and very often the victim or their family may not want a legal aid counsel. They may repose more faith in their own counsel. So a lot depends on case to case. Um, and I am sure that sensitizing anybody can only help.
Yes. Thank you, ma'am. Pinky ma'am, so we are in the middle of a global pandemic and things are bad. They're not the way they used to be. But crime doesn't sleep and the city doesn't sleep. So in such a situation, if we have fresh cases that are registered of rape, now what are the challenges with the defense, the prosecution, the judge, the police? Because you can't you there is physical distancing, so you may not be able to meet and carry out proceedings the way they were being carried out before. But at the same time, delaying, I mean, justice delayed is justice denied. So what do you think are the challenges and how should they deal with it?
No, you're right. There are tremendous challenges because a number of these issues concern physical requirements. For example, a medical examination. Now, at the first one of the first stages, so you have a medical examination which is required and in fact mandated by law today, as I mentioned to you, 164A, etc. But you cannot really go to a hospital as easily as you can. However, it's difficult to find any easy answers. The fact does remain that at least in today's time, institutions are working on requirements. So if there is a case, it would be ultimately there would be medical examination, and what possible safeguards could be taken would be taken. You're actually having virtual courts by and large functioning. You're not having the physical courts functioning. So you would have difficulties of recording, for example, sometimes the prosecutrix or the survivor's testimony in court. You would find difficulty as far as carrying out of investigation by the police is concerned. You would even find a difficulty to go for registration of an FIR to the police station. Forget the other parts, because today you cannot even go to a police station without the social distancing issue, and you'd be actually questioned right at the outset. However, as I said, these have become some kind of hurdles, but they are not complete hurdles. So you can meet them. And whatever it's worth, I must mention to you that crimes have gone down in this respect. Broadly, there are much lesser cases in this period, and you can understand the reasons. In fact, I'll quote to you what Modi ji said in 1940, in the 2014. I'm sorry, and he said, why do we always tell girls not to go out? We should actually keep the boys in.
Yes, I agree.
So with that kind of statement, it's the same kind of phenomenon. So if you, with the lockout, obviously there is lesser physical movement. Whatever it's worth, even crime has decreased. I'm not talking about, by the way, domestic discord, that has been on the rise, and some others. But given all that, the crime rate overall has not been staggering upwards or spiraling upwards.
Thank you, ma'am. Geeta, ma'am, so in many instances, we find prominent people, resort to social media and they tweet or they write a Facebook status saying that, men will be men and she should have, not worn skimpy clothes. She was asking for it. Or inki shaadi kara do, like Pinky ma'am said, and like you have also stated. And so what is now this is a question a number of people have asked us, what is the legal recourse that someone can initiate against such people who initiate such statements in social media?
This is a difficult one. I feel social media is an unruly horse, and the straight answer would be that if, as a sensitive woman or a sensitive man, I feel this is defamation of womankind, I could probably file a civil or criminal case for a class of for defamation. But normally what happens is that such people are so shamed on social media itself that they often do a retraction. But the problem is it's a thinking, otherwise you wouldn't make such statements. You wouldn't make such outlandish statement unless your thought processes want that. And you don't have to care about the thought process of one man or one politician, because he's come from the general people. He's come from the members of the public. So you have to you have to look at changing the mindset of people. And that again comes to proper education at home and at school and at the workplace and with your peers and your friends, and realizing that it is not, I mean, it's not proper to be thinking that way, and definitely not proper to be speaking that way, and definitely not proper to be acting that way.
Thank you, ma'am. Yes, I think we need to have social media, as you said, is an unruly horse, but we need to try and tame this horse by our own, by having a parallel sort of narrative established, which is
That's right.
which is positive in nature. Pinky, ma'am, I have a question for you on the mental health. So, mental health of rape victims is hardly talked about, and we have very few mental health laws directly affecting this. So, and there was an incident in Bihar, in a district court in Bihar, where a rape victim and her family was held under contempt and for being disoriented, like her state was disoriented. So, ma'am, what are your views on that? What do you think? How should we sensitize that aspect of the law?
No, you're right, Janvi. I mean, you're talking about this one case in Bihar. We've seen several cases where, in fact, rape has been committed partly because the survivor was mentally even challenged. But I was actually thinking when you're asking the question, you're going to be asking me more about the mental health of the accused. I think that's the issue which needs to be determined even more than the unfortunate plight of the survivor. I mean, there's nothing much you can say on that front except to say it's preposterous. Somebody's already either mentally challenged or mentally disturbed, so committing any act of offense of such as rape is obviously something which is highly condemnable without issue. But I do think somewhere we need to address the mental health of an accused. I do think these are broadly acts of perversion. Aside from the aggression, one feature that the social cause, the mindset. The other cause is perversion, and the third, I think, which is even more important, possibly, is the fear of law, as a fear of justice. Somewhere down the line, this deterrent philosophy in our world has to function better, to the extent that if there is punishment, there is retribution, then people would at least feel either whether they were wrong or right. Firstly, they should understand what is wrong and what is right. And for that, that mental imbalance situation, I think corrective both at educational as well as possibly at psychological levels is something which needs to be tackled. Two, I think uh, crimes are committed in series and they escalate. So you start from a lesser crime and it goes on to a higher crime. So if crimes by and large are controlled at the first instance, then possibly the same perpetrators. I'm just saying, for example, as you say, there used to be an offense earlier called 354, outraging the modesty of a woman. Of course, it was highly questionable and it was challenged. What is the modesty of a woman? Same thing like chastity. But the issue was you're troubling or harassing a woman short of extreme form of physical violence of rape. So if you can stop people and ensure that they are actually stopped both at the legal as well as possibly at the medical or psychological levels, then possibly the same aggressors may not transform themselves into committing a higher degree of crime. These are issues that concern me, and I do find that whenever you see this act is somewhere, this is all to do with broadly the mind. Yes. So the mental health is something which needs to be tackled, and I think while we handle the societal values and the mindsets and the archetypical and the gender issues, this is another feature that does need to be covered.
Thank you, ma'am. Geeta, ma'am, this brings me to my last question for this evening before I will release you and not waste more of your time. But, ma'am, so you spoke about different kinds of rape and you also spoke about that, the degree of severity. For example, a rape with the intention to commit rape and a rape where there are consenting adults, but there was one incident one day when it was not consensual. Ma'am, so what about marital rape?
What about marital rape? This is a very vexed question. I mean, in an ideal world, marital rape should be included as an offense. In India, because our investigation is so weak and our tools of investigation are so non-scientific, I feel that every person who would be in a bad marriage may not every person, that's many people may make it out to be marital rape, uh, in the same way as 498A, which is, dowry demands and harassment of women, was included for a very laudable reason, because there are dowry demands in India. But many cases of dowry demand are not genuine cases. There are many cases which will be genuine, there will be some which are false. Because in India, we just lead to a host of more litigation. So, in an ideal world, I would want marital rape, but I would not want false cases to come. Now, the question is, you have a whole penal code, and there are false cases of murder, theft, assault, 498A. Why not marital rape also? Because abuse of law will always be there as long as law exists. But since this is a law in closed doors, and in a sense, it's already a civil misdemeanor. It's not a criminal misdemeanor. But I think in Domestic Violence Act, marital sexual misconduct is part of the cruelty, to the extent that it's already a civil, quasi civil offense in the Domestic Violence Act. It's included. It's not added in the penal code. We have to ensure that there is some control on false complaints. But all said and done, I'm all for it.
Thank you, ma'am. I think that is the answer I was looking for. So, Dr. Anand and Geeta Luthra, ma'am, I would like to thank you formally on behalf of Lex Macula for coming today on a Sunday, taking out time for us and giving us such great insights, for clearing so many doubts that so many of us have. The number of messages and questions I've been getting while we've been in this discussion, I mean, it shows that there is so much that needs to be clarified to the public in general. And I think that is what you have done today for us, for law students, for laymen, for anyone who wants any kind of clarification on this major issue, which affects everyone in the society. So thank you, ma'am. Thank you so much. And I will now hand over to the organizers for them to say a few words.
Thank you so much, Janvi ma'am. Just first of all, warm greetings to everyone who stayed till the end. I've been bestowed with the honor of giving thanks to everyone who's involved in the session, and I think that's already quite a difficult task. But I just want to extend my heartfelt gratitude to both of our panelists, Dr. Pinky Anand ma'am and Ms. Geeta Luthra ma'am, who've taken time out of their busy schedules and enlightened us on this Sunday evening. I also want to extend a really big thank you to Janvi ma'am for moderating the session. She's been communicating with us back and forth on the session, and to be honest, the entire team at Virtual Lawyer for their support to this event. I want to also appreciate all the participants who stayed for the entire duration of close to 2 hours now, and have become part of this rather important conversation. You've given us your supposedly lazy Sunday evenings to discuss a topic that can be rather uncomfortable at times, but it's extremely important, and we thank you for that. And the entire point of this session was to carry on a conversation that at times I think diminishes, and we hope that you all take take from the session a spirit to keep having this conversation, acknowledging privilege in a lot of cases where you're a man, and acknowledging the fact that there is a problem. And we feel that only by that can we come closer to our goal, that is proper sensitization towards this horrid crime. Thank you so much to my entire co-team at Lex Macula, Krisha, Raghav, Bhavya, and Ariman. And thank you so much to our panelists and our moderator, Janvi ma'am, again. Thank you so much. I'll take your leave now. Thank you so much.
Thank you.
Thank you.
Thank you, ma'am.
Thank
So
you.
much, ma'am. Bhavya, could you confirm that we're off the live session?